At the very heart of our legal system, there's this constant, fundamental tension: a parent's right to raise their own child versus the state's duty to step in and protect that child from harm. And when those two powerful forces collide, well, families can be torn apart. Today, we're going to explore exactly how that happens. And look, the stakes here are just incredibly high. We're talking about a bond that the Supreme Court itself has called a fundamental constitutional right. Breaking that bond, even for a little while, is legally considered a deep, irreversible injury. That's the baseline, the starting point for every single one of these cases. So here's how we're going to break this all down. We'll start with the story of one family in North Carolina, a story that really brings these tensions into sharp focus. Then we're going to zoom out and see how their case is like a window into these deep systemic challenges. We'll look at the court's pretty controversial orders, the huge constitutional questions they raised, and finally, a major new effort to reform the entire system. All right, so let's dive into our story. It all starts with the case known as In Re MB. In late 2023, the Union County Department of Social Services, you'll hear them called DSS, gets involved with a mother, Kelly O'Neill, and her young daughter, Maura. And what began as a pretty standard inquiry? Well, it's viraled fast. It all kicked off with some reports made to DSS. That led to something called a juvenile petition. That's the formal legal document that basically accuses a parent of neglect. Just a month later, DSS takes what's called non-secure custody, which is really just a legal term for removing a child from their home. Right after that, Miss O'Neill agrees to a service plan, a list of things she has to do to try and get her daughter back. So this document right here, this is that juvenile petition. You can think of it as the key that unlocks the courthouse door. It's the piece of paper that gives the state the legal power to step right into the middle of a family's life. As this case moved forward, two completely different stories started to take shape. You had one parent who was, by all accounts, doing everything the state asked. And then you had another parent who, at least in the eyes of DSS, was digging in her heels and refusing to cooperate. I mean, just look at this stark contrast. Court documents show the father, Michael Bridges, he completed his parenting classes, he passed all his drug tests, no problem. But on the other side, DSS reported that the mother, Ms. O'Neill, wasn't showing up for drug screens and was communicating in a way the agency called volatile, and frankly, aggressive. And this kind of communication, it became a massive issue. The court filings are just filled with messages like this one sent from Ms. O'Neill to DSS staff. This complete breakdown in communication would end up having huge consequences, really shaping how the court saw her and what it decided to do next. So how did the court respond to this escalating conflict? Well, it responded with two really drastic and honestly highly unusual orders. First, the court ordered a total and indefinite ban on any contact, phone calls, visits, anything, between Miss O'Neill and her daughter. Second, it issued a gag order, which meant she was forbidden from talking about her own case on social media. So in one move, the court effectively severed her relationship with her child and, at the same time, silenced her. Well, as you can probably guess, Miss O'Neill fought back. She immediately appealed these orders, arguing that the court had gone way too far and had violated her fundamental constitutional rights. Her legal challenge really boiled down to three core principles. First up, due process. Her lawyers basically argued that this indefinite no-contact order was a de facto termination of parental rights. Think about it. It had the exact same result, separating mother and child forever, but it did it without going through the much stricter legal process and higher burden of proof that's required for an official termination. Second, the First Amendment. Free speech. The gag order was challenged as what's known as a prior restraint. That's a legal term for restricting speech before it even happens. And courts have said, time and again, that these are almost always unconstitutional. The government has to clear an incredibly high bar to justify one. And third, the Americans with Disabilities Act, or ADA. Miss O'Neill's argument here was that DSS knew she had diagnosed mental health conditions, but instead of providing reasonable accommodations for those disabilities, they just handed her a standard one-size-fits-all plan. And then they used her inability to comply with that plan against her. Okay, so now let's pull the camera back, because the kinds of problems we saw in the O'Neill case, they are not isolated incidents. They're actually symptoms of a much, much larger crisis happening inside North Carolina's entire child welfare system. One of the most glaring issues is this: racial disproportionality. Black children make up about 27% of all kids in the state, but they account for nearly half of all the children in the foster care system. A gap that huge, well, it points to a deep, systemic problem. And hey, it's not just advocates pointing these things out. In 2024, a federal review found that North Carolina's system was failing to meet standards in all 5 critical areas of how it reviews these cases. And this includes the very legal processes, like permanency hearings and termination of parental rights, that were at the center of the O'Neill case. So why is this happening? Well, these failures come from some really deep-rooted problems. The system is chronically underfunded, which means social workers are overworked and are constantly quitting. You've got wildly inconsistent policies across 100 different county agencies. And on top of all that, outdated computer systems create these dangerous blind spots, making it almost impossible to get a clear picture of what's happening to these families. So, in response to this mounting crisis, North Carolina lawmakers decided they had to do something. In 2025, they launched a major legislative overhaul to try and fix these problems that have been festering for years. The proposed solution is called the Fostering Care in NC Act, and it tries to tackle these issues head on. It gives the state more direct oversight to fix that county-by-county inconsistency. It creates rapid response teams to help kids with the most complex needs. It forces insurers to start mental health assessments within 72 hours. And really importantly, it adds new protections for parents, making it clear you can't lose your child just because you can't afford to pay child support. At the end of the day, this one family's story and these big reform efforts, they all push us right back to that fundamental dilemma we started with. When the state has to step in to protect a child, how do we make sure we don't destroy a family in the process? It's a question with no easy answers.